Hi, Kuzang for everybody. Hope everyone is doing all well. So, with the recent decrease in country level, especially for Bhutan, from being previously a level 2 country to now a level 3 country, and with many onshore students pursuing in actions such as changing courses, changing institutes, hopping from one visa to another, which is seen as visa hopping, there has been a slight increase in visa refusals. So now, once a student visa is refused, it causes many people to, like panic, stress, and, not know what to do next. And the common term that goes around is ART, ART. Many people keep saying that, but they don't really know what the meaning of that is and, what are the steps to it, what needs to be done, and, who to approach. So that's why we have our registered migration agent here today with us to help really, help you all clarify and, help you guys understand what it truly means, the ART, what needs to be done, and what the process of it is. So without further ado, let me get right into the questions. So let's get on to the first question now. So what is the Administrative Review Tribunal, also known as the ART?
Thank you, Jimmy. Hi, everyone. The ART is an independent body that does the merits review of the decisions made by the government departments at the federal level. So if I can give some examples, the decisions taken by the Department of Home Affairs with regard to visa refusals and cancellations, decisions made by the Services Australia in terms of Centrelink decisions, and also the decisions made by the Australian Taxation Office with regard to tax assessments, GST, etc. So overall, it's an independent body that sort of does the merits review of decisions made by these departments. Now, if we go back to October 2024, it was the Administrative Appeals Tribunal. So earlier to 2024 October, it was the AAT, which came into existence since 1976. So AAT was replaced by ART in October 2024. And what are the changes? If someone wants to know, it has become more structured. It has brought in more efficiency. And even the ART Act was passed in 2024. So basically to bring in efficiency, transparency, and all sort of making the system more dynamic, more faster, the ART replaced AAT.
Okay. So now, let's say someone's student visa has been refused. Is there like a particular time on when they need to apply, or is it like if my visa gets refused today, could I apply the next day for the ART, or can I apply in a month's time, or like what's the time limit?
Okay, that's a good question because it's normally mentioned in the visa refusal letter. So Jimmy has mentioned visa, but let's take student visa as an example. So when a student visa gets refused by the Department of Home Affairs, the normal deadline is 28 calendar days. So if your visa is refused today, you must make a merits review application to the ART within 28 calendar days. Now, when I say make an application, if you're onshore, yes, you have that opportunity to make that merits review application. But if you're offshore, most of the applicants don't have opportunities. I would say 99% of the applicants don't have an opportunity. But there are situations where an offshore applicant can also get merits review application. But for student visas, it is not possible. For some classes of visas, like for example, visitor visa, some visitors visa where the applicant is say in Bhutan, but they have like a permanent resident relative here or citizen relative here. If their visas get refused, ART provides them the opportunity to make an appeal even if they are offshore. But student visas, no way. Only onshore based refusal applicants, they can only appeal.
So who can represent the applicant in the hearings?
Right. So, as per the Migration Act 1958, the authorized persons to represent somebody for migration related decisions, like, for example, appealing or making a merits review application to the ART on behalf of your client, it's either an immigration lawyer or a registered migration agent like me. So these are the only two authorized professionals who can submit an merits review application on your behalf. You can also choose to do it on your own, but if you are looking for professional help, these are the only authorized people.
Okay, so recently I've been scrolling through social media and I've been seeing a lot of posts from other registered migration agents and migration lawyers about the importance of the written submission. So how does that work? Is it like, does the written submission have to be done very well now? Does it include, like, if it's not a good submission, do you get invited to the hearing, or how does that work?
So just to give some more context to this now, the way the whole the merits review was structured before is that when somebody's visa was refused, he or she would submit a merits review application, most probably through the same professionals like immigration lawyer or registered migration agent, and a hearing was inevitable, which means that once you submit that merits review application, a hearing date would come sooner or later. But since the processing time is quite long, because at the end of the day, everybody's whose visa gets refused, they ultimately submit the marriage review application to the tribunal. So the cases are just getting piled up, and the wait time for a hearing could be as long as like 2 years, 3 years, and in some cases more than that. Whereas very few cases get heard in like less than a year. So now, what Jimmy was mentioning is that there has been some reforms within ART where they may not hold a hearing, which was existing before. Like, hearing would be done irrespective of how the submissions were made, which Jimmy mentioned, the written submissions, whether you make a written submission which is well drafted or not, whether you don't make a written submission but just submit your merits review application, a hearing would be held. But now recently, with the reforms in place, what the ART can now do within the provisions of the legislation, the same ART 2024 Act that I mentioned, what they can do, they can exercise their authority to base their decision on the submission that has been made, meaning that they can decide some cases without a hearing. So that's where the visa applicants whose visas have been refused need to be very cautious, because now that the ART has made it quite clear that they are going to look at the written submissions, so they need to make sure that the written submissions are done well. Now, when I say done well, written submission basically comprises of evidence-based submissions. Like, when I represent a client, for example, now if I make a submission, now I will have to base my submission on the Ministerial Direction 106, which is basically assessing the genuine entry requirements, the genuine student requirements of somebody who wants to study in Australia on a student visa. And there are so many factors within that Ministerial Direction 106. So the Department of Home Affairs has refused the visa because they felt that the visa applicant does not satisfy the Ministerial Direction 106. So in your submission, you have to highlight as to how they satisfy that Ministerial Direction 106, and you have to back it with evidence. See, when I say back it up with evidence, you have to refer other ART cases. Because see, if you look at other tribunal, ART in short tribunal cases, there are a lot of decisions that have been affirmed and at the same time decisions that have been remitted. So remitted basically means they have sort of favored the visa applicant. Affirmed basically means that the tribunal also agrees to the decision of the department to refuse the visa. So if you look at the repository of ART cases that have the hearings that have held over the period of so many years, you can see a lot of evidence where some of the visa applicants' cases were remitted, and those cases are similar to your client's circumstances. So that's where you sort of pick it up and defend. You write it in your submission that my client's circumstances and the case that was remitted, say in 2022 or 21, is similar, when the tribunal at that point made a decision in favor of the visa applicant, that sort of is also applicable for my client. So see, this is one very small example of how that written submission is. And then you need to add a lot of other justifications as to why you satisfy that genuine student requirement. So see, in short, the written submission will cover a lot of aspects, mainly the things I mentioned, like addressing the Ministerial Direction 106, and then also referencing to successful cases of the tribunal in the past. These things will help build a good submission to the department. And now that they can decide the case without a hearing, you need to be bang on with your submission. Your submission needs to be done very well so that they ask you to come for the hearing.
Okay, so now let's say after a client's written submission has been submitted and they have got the opportunity to attend the hearing, how are the hearings held? Is it an in-person thing or is it like an online facing? How is it like structured?
So yes, so it's a mix of both. Normally the hearings are held like in person, where a member of the tribunal would be represented by like a person who has the authority to represent the tribunal, and then the visa applicant whose visa has been refused, he or she would be attending the tribunal hearing in person. And then if they have like a registered migration agent like me, or an immigration lawyer who has provided them that support to submit that merits review application, so they will also attend the hearing with the visa applicant, their client. So mostly in hearing, but the tribunal also conducts such hearings virtually. They normally use Microsoft Teams, which is an app which I'm sure you all know. It's similar to Zoom or Skype or the online virtual platform. So you can also have like a virtual setting. You can have an in-person setting. So it depends. And you know that when the date of the hearing is announced officially in an email sent by a representative of the ART.
So now, can applicants provide new evidences which weren't previously provided to the department?
So yes, you can provide evidence until the hearing stage, like until few days uh, of the hearing. So it's like a continuing process, and as and when circumstances change, if there are new developments that wasn't there at the time of drafting that submission, which we just talked about in great details, so you can make your case stronger as and when new developments take place. So you need to inform the ART through the appropriate channel that, okay, I had made a submission last time, but this is another evidence I would like to attach as part of that submission. So it is doable, and it is better to do so in case circumstances change, because it makes your application more stronger.
So now, once your ART has been lodged or appealed, do you automatically get a bridging visa like you normally do when a student submits their student visa application to get issued a bridging visa A? Is it the same case with the ART?
The way how it works is that when your substantive visa, like the visa that you held prior to applying for the new visa, and that new visa eventually got refused. So that substantive visa, when it expires, like Jimmy mentioned, you get that bridging visa A, which gets activated, which allows you to stay legally in Australia until a decision on the new visa application has been made. Now that the new visa application decision has been made and it has been refused, so we mentioned about the 28 calendar days. So that bridging visa A will also stay active for that amount of days. Now, if you make a merits review application, what happens is that the bridging visa A after 28 days sort of continues, but it doesn't happen immediately. There's a bit of a time lag. So that's where the confusion is, because then I get a lot of queries from some of my clients. Hey, my ART marriage review application was lodged, but my bridging visa A has sort of expired. So this happens because say you submit within the 28 days deadline. So when you submit an application to the ART, the system sort of logs it, but it is the tribunal communication that goes to the Department of Home Affairs, because eventually that bridging visa A being extended is the prerogative of the Department of Home Affairs. Tribunal is just the one who takes your marriage review application on board and they notify the department, but in that whole process it takes some more time. So eventually you're in a phase where your bridging visa A doesn't seem to be active in the system, but that does not impact you in any way as long as you submit your marriage review application within the 28 days. That's something outside your control. That's something outside the control of ART. That's something out of the control of the Department of Home Affairs. But visa applicants do panic, and I can understand why they panic, because when you see that you don't have a visa in the system, which basically implies that you're an unlawful non-citizen. But just letting you all know that no issue at all. It is fine, and yeah.
Okay. So now, how can proper initial visa preparations help reduce the risk of ART? Like, is there anything that can be done differently, or is there like some more evidences to use to help reduce that risk?
So see, now I think that's an important question, because it's like part of the mitigation measures. See now, okay, we're talking about the refusals and how that appeal process looks like and how many days you need to appeal. So it's what if we did not get there? Mitigation measures. Now, see, the main thing to note is that the department is assessing your genuine intent to study in Australia. So Jimmy mentioned in his opening statement that a lot of refusals are happening because there's the visa hopping taking place. The people are changing their education providers, people are changing their courses, and then obviously the country assessment level dropping from 2 to 3. That's a red flag. But that being said, if students can avoid not to change their college, the education providers in the first place, that would be the most appropriate step. But eventually, if you have changed college, it's already too late. And then you need to the genuine student requirement, the GSR. I think we covered this in one of our episodes when we talked about the student visa, but I'll just highlight some aspects of it here because it's relevant. If you try to address the genuine student requirements and make sure that you address all the factors which are pointed out in the Ministerial Direction 106, thereby proving that you're a genuine student. Now see, people might say it's hard to do but easy to talk about it. I understand. But see, if you look at how many things are happening, for example, how the GSR statements are being written, it's very generic. It's just the right. It's not backed by evidence. See, department needs to see a lot of evidence. If you have written something in your GSR statement, commonly known as SOP, they need to be backed by evidence. If you don't have evidence, no matter what you write, it doesn't hold weight. So likewise, you need to make sure that your GSR, even for changing colleges, is drafted so well in line with the policy, the regulations, so as to build up a strong case and to show to the department that I had to change college due to certain change of circumstances that were outside my control. So these sort of things have to be built in, and then you also need to make sure that you do it well so that you minimize the chances, you mitigate the risk. See, now, even if you do that, refusals might happen, but at the end of the day, you are at least happy that you tried your best to avoid a refusal. So, if you can avoid a refusal, why not? But if a refusal happens, it's not the end of the world. ART, the independent body, is there. That's an independent body. The word independent body, it's not going to back the department. It's going to look at your case on its own merits. So that's why you need the professional support of a migration lawyer, the immigration lawyer or registered migration agent. So that's important.
So now, can someone go to the Federal Circuit and Family Court after ART if they affirm the decision, the so-called judicial review? And is it about the merits of the case or legal error?
So see, now I think what Jimmy is getting at is that, say for example, your visa hearing was done, and then Jimmy mentioned if the tribunal, affirms the decision of the department, which basically in common terms means the tribunal has also supported the department's decision to refuse the visa. So that means tribunal is not going to accept your merits review. Now, what's the next step? Just let's correlate it to a similar situation where in Bhutan you have your district court. If a district court passes a judgment and you're not happy with it, you go to the high court. Likewise, if high court decides in favor of the district court's decision, and then you can appeal to the Supreme Court. So over here also, the family court and federal court circuit is the next level of the hierarchical model where you can challenge ART and submit your appeal there. But many people are not clear, and I think this is a good opportunity to make it clear. In ART, merits review is taking place. Your case is going to be decided on merits, whereas in the family court and federal court circuit, your judicial review is going to take place, which basically means they will only assess if any misinterpretation of the law, if any legislative errors have been made. So it's more like department or tribunal not understanding the legal provisions and using it differently, not in the right way, leading to the affirmation of the department's decision. So it's just the judicial, the legislative side of things. So that's where, if there's no legislative error made, there's no point in appealing to the higher ups. So in my experience, ART is the level where you have a good chance at making the ART remit the decision in your favor. If they don't, going up is not going to work unless the department and ART have misinterpreted the legislative, the provisions of the law and made some legal errors which can be challenged at the higher up courts.
Okay, so now, the final question. While waiting for a hearing, which you previously mentioned takes quite a bit of time, with the minimum time being almost 1 year to 2. So during that waiting time, what are some opportunities that the client can undergo or as alternate measures?
See, that's very important. Now, the clock is ticking, and like I mentioned before, the hearing takes a lot of time. But now again, with what we just discussed, if the submissions are not good, There may not be hearings, the decisions may come very fast, but eventually, if there's a hearing, there's a backlog of cases. Cases have been piling up over the years. So 1 year, 2 years, 3 years, you never know how it's going to go. So see, while your hearing date is going to be announced sometime in the future, like Jimmy mentioned, what can you do? So you really need to explore other opportunities. For example, say you have an occupation on the skill occupation list. It's fine. You're a visa refusal, applicant, but it's fine. You are barred by Section 48 of the Migration Act, where you can apply for some visas, but you cannot apply for all the visas. See, for example, Section 48 allows you to Section 48 doesn't bar you from applying for that skill nominated visa 190 and the 491 visa, the regional visa. So if you have an occupation or skill occupation list, if you have a skills assessment done, and if your points are competitive for you to get an invitation from the state for 490, 491 and 190 visa, you can express your interest, and you can, if you get invited, you can lodge that visa and withdraw your ART application. See, that's one scenario. The other scenario, say that you have an employer who wants to sponsor you, and you have your occupation on the core skills occupation list, or the employer has a labor agreement or a designated area migration agreement, in short called TAMA. See, if those arrangements are in place, and if you have the qualification and the work experience, then you can easily get sponsored for these visas. But Section 48 bars you from applying for visas like 482, 186. But the way it can work out is that you can apply for these visas offshore, come back to Australia, and then go on a different bridging visa, and then withdraw your ART application. So see, now these are opportunities, and sometimes these opportunities don't work out for everybody, but it does work out for some. I have few clients, due to confidentiality, I may not be able to disclose their names, but they are now doing their job ready program. So once they do their job ready program, their skills assessment is done, they will express their interest, and they have high chances of invitation because they are in the building and construction sector. Their trade occupations are in that sector. So there's a lot of information that has come today, and obviously if you want to know more, please contact us, and I am more than happy to help.
So thank you everyone. Like Sir Ngaun said, there was a lot of information to take in today. And some key takeaways that I thought was very important was that there's 28 days after refusal to make sure you get an application done, and that, as you guys heard, the importance of the written submission now, as your hearing depends on it. So make sure you reach out to a registered migration agent like our sir here to deal with such cases. And that lastly, I think, since what do you say, how the hearings are held, it can be either in person or online, whichever is decided. So any more key facts that you think is important to share?
I think I'll just reiterate, this is very sensitive, it's very important, it can make or break it. So that's why I know getting in touch with a registered migration agent like me or an immigration lawyer is not cheap, but at the same time, if you really want to get a good shot at having the decision remitted by the tribunal, and the tribunal deciding in your favor, we are the professionals that can make it happen. So you should not think that if we take them on board, still we could get a decision that is not in your favor. Well, it can happen, but at the same time, you need to maximize your chances of securing a win at the tribunal. So that's why don't just do the submission yourself, for the obvious reasons that they may not call you for the hearing and decide based on the submission. And you also have legal advice coming from authorized persons like a registered migration agent or an immigration lawyer. So it's always better to go along these lines lah.
So that is it for today. Hope you guys enjoyed the show today. Hope you guys enjoyed the video. Please make sure to like, subscribe, and turn the notification on for some more. And there'll be more videos coming soon. Thank you.
Thank you.